Hey, how are we doing? Welcome to Your Successful Retirement. Your Successful Retirement. Today we're going to talk about living trusts, and it's a couple months ago we did the history of the will, which I love that topic. That's just a fun topic. I'm like Mr. History. Anyways, anything dealing with the Declaration of Independence, and that carries back to the Magna Carta. Listen, go back if you haven't heard it, go back. It will help for good backstory to this episode of Living Trust. Because I kind of hinted during that episode that, some of the issues that we have with wills and with probate can be mitigated by a living trust. So I wanted to kind of talk about that. If you don't want to go back and give you like the 30-second version is our version of estate settlement through the probate process really goes back to Old English law, and it goes back to the Magna Carta 1215. That this wasn't the only thing, obviously, that the Magna Carta did, but what it did was it limited the king's power. The king had absolute power, even though there were laws that said, "Oh no, the lords own their own manors." The king still had an absolute power above that. And the Magna Carta created this thing that I remember hearing for the first time when during the Clinton scandal and impeachment hearings was the rule of law. That was when it was created, is nobody is above the law, that the law is the law of the land, and that's it. And that's what the Magna Carta created, and it allowed for property ownership to be true property ownership by these lords of the manors. And how they settled their estates became what our probate process is today. You pass away, you go to the court, you present the will, the court reviews the will, you then prove that you're the person that's in charge of the will, you prove that the will is valid, you open it to the public, and all of that, and it's a lengthy process. It's potentially a costly process if you're hiring attorneys to do so, even there's also court costs beyond that. It is a ridiculously time-consuming process because it just takes time. The courts are very slow. I had a client recently. Her brother passed away this previous summer, and Massachusetts is notorious for having a very slow probate process. She did it in 7 months. She did it in 7 months because she is a very driven woman, and I love that about her. And every time she could go down to the courthouse to kind of poke and prod, she did. So 7 months, I would bet, is the absolute minimum in Massachusetts. In most people, it's longer than that. I did see one estate settlement with a lawyer of mine that we work with a couple of years ago. That was only 9 months. I was very surprised. And it was a case where there was no will. I was very surprised it happened in 9 months. The courts they were very efficient at that time, but that ebbs and flows. So we have all of these issues with the probate process. And a lot of people said, well, just get a trust. Just get a trust. Great idea. Which trust? Because we think about it and we think, well, isn't there just one? And I've been doing this for a long time, 34 years. I got my start really when I was in college. I worked at a trust company in Boston, and they were an old school trust company. Like they're not today. I looked them up on their website a couple months ago, and it was shocking how different the company was. They're like cutting edge in this, and they were fossils 35, 40 years ago, like fossils. But they were dealing with old money, like old Boston money. That's what they were managing at the time. They still may do some of that, but they've expanded from there. But I was exposed to a bunch of different trusts. You've got revocable, you've got irrevocable. Talk about that in a minute. Life insurance trust, Medicaid trust, nominee trust, charitable trust. You've got your crits, crats, and cruts, and your grits, grats, and gruts. And you're thinking, what? And a crit or a crat or a crut is a charitable trust. Is you set up a trust that provides you with income during your lifetime and then reverts the money to charity. A grut provides, the grut provides somebody else with income, and then the money reverts back to your estate at your death to pass on to whomever. It's all of those tend to be trusts that the very, very wealthy do. And that's why I had to think about the grantor retained trusts. Because they're so infrequently used. But gosh, you go through, my son-in-law is going through his CFP final. He's taking the final test, is this comprehensive exam in about a month. And he's having to go through all of this. And I keep looking going, I don't know why they teach this. It's kind of like teaching calculus to high school seniors. It does expand your brain a little bit, but at some point it's the useful knowledge. But so you have all of those type of tests, trusts rather. I actually have a client that he has a CRUT, a charitable remainder unit trust. And that means that he put the money in, a charity will receive it at some point, and he can take unequal cash flows year by year based on how much money he thinks he needs. And he set this up 20 years ago with a local attorney that, kind of a little bit against my wishes. I thought it was more complicated than necessary for the size of it. The funny thing is, for 20 years, and it's just about this time of year, his most important thing is he needs the tax documents so that he can file. We're in late February right now, 2025. And every year he calls up and he's like, yeah, I need the tax documents for the CRUD. And I try to correct him every year. You mean the CRUD? Yeah, the CRUD, C-R-U-D, the CRUD. And I'm thinking that little thing that's in the corner of your eye, no, the CRUT. So there's all of those. There's also this thing, again, Justin going through this reminded me of this, and I haven't seen this term since I took the CFP literally 30 years ago this year, possibly this week, the anniversary of taking the final test, was a rabbi trust. And he's like, what the heck? Why did they call it a rabbi trust? And it's an obscure trust that's used by small businesses to protect a potentially liability-laden retirement plan for the owner from creditors. It's a bizarre thing. They just exist. There's a whole bunch of different trusts. But when people talk about, I think I might need a trust, they say, I think I need a living trust. Okay. I think I need a revocable trust. Okay. I think I need a living revocable trust. Okay. Those are all pretty much the same thing. Sometimes they'll even say, or I'll see, I haven't seen one in a long time. It'll be the loving trust. And that's with trademark. What the heck? And there was some company that was selling this trust, this living trust, to lawyers to resell to their clients, repackage it, put person's name in and all of that. And it was called the loving trust because they had packaged it so well. I guess I'm not hung up on that, but living revocable trust is what people are talking about. And let's talk about what those terms mean. Living is created during your lifetime. It means you're living when you create it, as opposed to a decedent trust. So after you're deceased. The second is revocable. That means you can change it during your lifetime. Nobody else can change it. Either before or after you pass away, you retain the right to change it at any time. Once you pass away, it becomes irrevocable or not revocable. Now, the difficulty is when you talk to attorneys, they have this special language they use called attorney speak. I remember the Clarence Thomas hearings. So we're going way back, 84, 83, 85, somewhere around there. And remember, there was the woman that accused him of sexual harassment. And that was it wasn't harassment, it was harassment, because that's how attorneys say harassment. They say harassment. Well, the same thing with revocable and irrevocable. You can hear the difference, right? Attorneys, revocable, irrevocable. Did you get that before the second one? That is irrevocable. That's why I'm very clear with all of my clients. It's revocable and irrevocable so that we know the difference, because sometimes we do create irrevocable trusts in our plans. They're not the greatest solution. There has to be extenuating circumstances. Most times we want the trust to be revocable. We can change it. We can change the beneficiaries. We can change the trustees. We can change the terms. All of that can be changed. So that's what we have. Now, if you've seen one, if you possibly have one, and maybe you just had an attorney say you need this and you did it and you didn't know anything and now you're learning about it. If you read the trust, gosh, it looks an awful lot like a will. It really does. In the early pages, it'll talk about, well, I created this and someday in the future, I'm going to I'll pass away and this person is going to take over for me. Okay, that's really good. And at the end, It'll say, when I pass away, I want these certain things to happen with my assets. Gosh, that looks an awful lot like a will, doesn't it? Like almost identical. It's probably double the size, sometimes triple, depending on how complicated, who's drafting it, things of that nature. But it looks an awful lot like a will. Why do we need this versus a will? Well, again, we talked about the will goes through probate. The living trust during your lifetime is effectively you. You are your trust. The trust is you. To the extent of if you have assets owned inside of your trust. So you have a brokerage account or a piece of property that's spinning off income or a piece of rental property or a bank account, and you receive the 1099s at the end of the year, the K1s or whatever, it will say the so-and-so revocable trust. And you will file that with your income taxes, because the fact that you have the right to revoke it and withdraw money from it means that it's effectively you for tax purposes. But when you pass away, you cease to become a person. Again, let's talk about things legally. You don't own anything at your death. You cannot. You don't own your own body. People talk about, I'll give you a quick funny, is years and years and years ago, I had a former business partner, and he had a client back in must have been the 80s, maybe very early 90s, who was a professor at a local university. And within his will, he wanted his body to be stuffed and mounted outside of his favorite classroom. I kid you not. That was exactly what he requested. You can request all you want. You're not a person anymore. We don't have to do what you say. Is anything related to that is subject to some extent, the executor at that point. The fact that I'm pretty sure it's not legal to stuff and mount a human being is secondary. And then he required that his wife, who was the executor of the estate, that if the university didn't want it, she would have to place it next to the mantle, next to the fireplace in their living room. Yeah, fat chance. So that's what you're dealing with within a will. With a trust, what we're looking at is the trust, once you pass away, hasn't ceased to exist. It still exists. So all of those assets held within the trust are owned by an entity, that entity being your trust, and a new trustee steps in. And the wheel's starting to spin of, wait a second, I don't have to go to probate, because you remember from 2 months ago, probate is for assets that don't know where they're going. If you have a beneficiary on an IRA, it doesn't go to probate because it knows where to go. If I have a living trust that owns all of my assets at my death, all of those assets know where to go. There is no probate. So that's really important. So that's the biggest advantage to drafting a living trust, is simplification of probate. Couple things it can do for us. Number one, it's going to cut down on all of those complexities of probate. The time, the cost, and the publicity is going to all disappear. So a good example is, when my grandmother passed away, my mom's mom passed away. She had a living trust. She owned no property. And I do this for a living. This is got to be 20 years ago. I do this for a living. I should have known better. I still called the attorney that drafted it. She had a living trust, her, my grandfather, and all of their assets were in the trust except for like one bank account that was joint name between her and my mom. My mom's an only child. And she passes away. It's about a week and a half later. I call the attorney and I said, hey, I just want to know what I have to do. I think I'm pretty sure, but just want to clear it with you. He said, okay, sure. Let me ask you a couple of questions. Sure. Any property outside the trust? I said, just the bank account, joint name with my mom. Okay. Any real estate? None. Everything's inside the trust. Yeah. Have your mother sell everything and write herself a check. And that's it. It was 2 weeks later, 2 weeks after she passed away, we could have settled the estate. I waited a week and a half to call him because we were in a real rush. That's the advantage of a trust. Nobody else had any say. It wasn't public at the court. Nobody could go in and place a claim against the estate or see what's going on. And we didn't have to spend thousands of dollars on attorney's fees and probate costs. So that was a big deal. So that's a big deal of why you want to do that. A second reason you'd look at it is retaining control. So if you're younger, and you have minor children, or you want to name grandchildren or nieces and nephews and they're minor children. Doing so and controlling those assets from beyond the grave, of saying, look, little Susie is not old enough to handle this money. I want to leave it for her, but I want to make sure that she gets it at age 21, age 25, at age 30, whatever it is. Doing that through a will causes that will to stay in probate until little Susie reaches 21 or 25 or 30 with all the associated costs. By doing a trust, we can simplify that. The trustee just keeps active and there's no additional cost. There's no additional probate. There's no additional publicity, all of that. Also handy if you have a special situation with maybe a child who's just unable to handle their finances on their own for whatever reason. It may be some sort of handicap. It may be that you just don't, they're not, they didn't turn out as they're just not as responsible enough as they could be, I guess is the best way to say it. And you're concerned for them. The trust allows you for that control from the grave of setting up so that you can protect them from whatever, from other people, from themselves sometimes, making sure that they're taken care of with those assets. It provides an ease of management. Again, looking at the example with my grandmother, man, it was simple. We had to present a death certificate and a copy of the trust. And everybody just said, to my mom, you're the new trustee. Tell us what to do. And it was very smooth, very simple. That's a big deal, is to be able to allow somebody not to have to prove to a court that they're in charge, which can take sometimes months. It's instantaneous. With the death certificate and the trust, the new trustee can step in. Or even before somebody passes away, they can resign as trustee of their own trust and allow the successor trustee to step in and manage the affairs while the person is still alive. So that's a big deal as well. One that can be an advantage or disadvantage in 2025 is you can have a single trust for a married couple. And this can be very advantageous. It can also cause problems that you don't want to deal with. Remember that your will is just for you. There's no such thing as a joint will. It's one person. But with a trust, you're allowed to have all of that stuff built in, all of those, I want Susie to get this and Joey to get that, and this percentage of this person, this percent of that person. If you're in agreement between the two of you, having one document is a lot easier than two. It allows you an ease of changing things on an ongoing basis. It also can allow for potential estate tax savings. That may or may not be important depending on your situation, but it allows for that. It also can be a detriment. I would not recommend in most cases, not all cases, but in most cases for second marriages, I would recommend against a joint trust. It would make more sense to have two separate trusts at that point, just because one of you passes away and you have children and everything passes to your spouse, and your children from the first marriage don't have really any control of that. So you want to be aware of that. But it's possible for a married couple to have a joint trust, which simplifies a lot of things. Some of the pitfalls that we look at, there's not that many. First is cost, and we'll talk about that at the very end. That's a pitfall. I find that some attorneys are very pro-trust. Some attorneys are very anti-trust. I don't mean antitrust, but you know what I mean. Not like monopolies. But I see people that bump into problems and they have to be careful. And the first thing is naming a trustee. And if I had, assuming that somebody needs a trust when we're working with them, this is probably the biggest sticking point when there's a sticking point. Who to name as trustee. Now, if you're over the age of 60, usually it's one of your kids, assuming you have children. If you're under the age of 60, usually it's a peer, brother, sister, something like that usually steps in, sometimes cousin. But there can be times when that becomes difficult. So for instance, you're over 60 and you don't have children. Who do you name as trustee? Everybody you know is a peer. What happens if they pass away before you? Do you really want an 88-year-old when you're 88 and pass away, managing your affairs and settling your estate. No. Oh, and that adds a lot of complexity. What do we do about that? How do we pick someone? That can add some sticking points. You want somebody that's trustworthy. It's not a complicated job. It's not a job that they have to have a strong legal background. It's managing your affairs. It's settling up. So if somebody's good at just regular finance, household finance, balancing checkbooks, paying bills, things like that, that's the person you want. So you don't need somebody with a rocket science degree or anything like that. You want to make sure that somebody, I would recommend against, if at all possible, any sort of what's called corporate trustee. That's somebody who's not related to you at all by blood, marriage, or friendship that will charge to do so. Which brings me to a story in a second that double relates is you want to be careful not making things too complicated. And it's the point of a trust is you can add a lot of complexity, but at some point it becomes just too complex and becomes a hassle for other people. So I had a client, passed away 6 or 7 years ago now. And he was one of my first clients. So 34 years ago, he became a client. And this wasn't something he did at the spur of the moment at the end of his life. For 30 years, he was talking about this and he made changes to his estate plan, but this central tenet was the same. He had, I think at the end, before he passed away, 23 beneficiaries, 21 human beings, 2 charities. When I die, I would like the income every year divided by 23 and split between the various people. And as each person passes away, their share gets split by the 2 charities. You can already see the math problem, right? The math problem is just a pain in the neck. I had simplified it a lot and we got it down and figured it out. And, spending time after he passed away with the trustee, which was his nephew, with his CPA and with his attorney to kind of figure out the last draft of this trust, how it really was to be executed. And then when the last human beneficiary passed away, the principal was split between the 2 charities, which could have been 30 years longer, potentially, because the client was probably 91 or 92 when he passed away. Beneficiaries were all next generation, so they were in their 60s or 70s. One of those 60-year-olds could live till 90. You're talking another 30 years. It's way too complicated. It wouldn't be bad if he had an estate of $10 million. He had an estate of less than $2 million. So the checks people were getting were just not significant. And this poor nephew had to deal with everything. And there was a provision within the trust, that he was allowed to resign as trustee. And he was like a local cop. That was his upbringing was he was a cop. He wasn't some financial genius. He was just a police officer. And at some point he was allowed to resign as trustee and this bank was going to take over. And we had long conversations over about a 2-year period before he finally resigned, that once he resigned, it was likely that the vast majority of the income every year on the trust was going to be eaten up by trustees' fees because the estate was so small in the first place. It just wasn't significant enough to generate the revenue to pay the trust, the bank, and to distribute money to the beneficiaries. And he said, look, I'm 70 something years old. I'm tired. I can't do this anymore. I just need to let it go. So be careful making things too complex, number one, and be careful of a corporate trustee, because a corporate trustee can end up taking a huge chunk of the estate. I have another client recently, his aunt, I believe it's his aunt, passed away with a trust, no probate. It's been over 2 years. And the trustee's fees by this law firm, which is the corporate trustee, is something on the order of 5 or 6% of the estate value, which I'm appalled at. I am just appalled at. Again, I settled my grandmother's estate with my mom in about 15 minutes. Okay, there's a piece of property they had to sell. So sell the property. Get your appraisals. put it up for sale, sell it, consolidate the money, write checks to everybody. It's not that complicated. 2 years later, and they've taken about 5, 6, 7% of the value of the total estate already in fees, and it's not over. Be careful of that. So those are the advantages. Those are the pitfalls. And you're sitting here thinking, do I need one of these? Let's talk about maybe. So let's go down a list. And this is really where, as financial advisors, we spend a lot of time with clients, is when we talk about estate planning with our clients through the financial planning process, like the initial financial planning process, we probably spend 2 meetings just talking about estate planning before we ever put anything really to paper in terms of what our thoughts are. And then we probably spend another meeting after that, honing that down. And then we call the attorney and sit down with the attorney. The attorneys are always amazed at how prepared our clients are, because we need to know everything that's going to happen, because some of these issues that we're going to talk about right now really relate. So size of the estate. The bigger the estate, the more likely you are you need a trust within reason. Within reason. Sometimes not, but within reason. I would say the absolute bottom end, in my professional non-attorney opinion, maybe $500,000. If you have less than $500,000, it's probably unlikely, all things being equal, that you would need a trust. That it's probably more complications than is necessary. How much real estate do you own and where? The more real estate you own, the more complicated it is. The less likely you want to go through probate. Probate with real estate's a pain in the neck. It makes it worse. If it's in different states, it makes it even worse. I do have a client right now. They own a place in the Bahamas. They just bought it. It's lovely. It's going when they pass away, assuming they own it when they pass away. They're fairly young. If they own it when they pass away, that could add some complexity. They've done some work down there already. It's in an LLC, I think. So thankfully for that. So we've already pre-worked on that. But if you own property in multiple states or, in another country, living trust might be more attractive at that point. Complexity of distribution. We've talked about this, is if you want to retain control beyond the grave, beyond that year after you pass away, a trust is probably a better option for you. And then a desire for simplicity. I will tell you, regardless of all of those other categories, the number one, what's the word I want? The number one reason when somebody walks in and just says, when we start with the estate planning, I want a living trust. Do you know what the number one reason? Their mom or dad passed away and they had to settle the estate. And they said, I don't ever want my kids to go through this. Never, ever. I want a living trust because I don't want them to spend months and months and months waiting for this and that. I want things as simple and tidied up as possible. And that's a big deal, is a living trust is going to make things easier for the next generation. That doesn't, is some people don't care. I once had a client. He didn't remain a client very long after this. Because I don't know what to do with that attitude. And he just said, we were talking about estate planning. He's like, what's the cost? And we'll talk about cost in a second. I told him, he's like, yeah, I'm not paying that. I said, well, it's going to save your kids this amount of money. He said, I don't care. If they want to pay it, they can pay it, but I don't care. I don't care if the attorneys get all the money. That broke my heart as a dad. It's like, how bad are your kids, or how bad are you? That there's just that disconnect there. And there was, not the one kid, multiple children, and I don't care about any of them. If they want to pay for it, they can pay for it. Other than that, we're all set. Okay. Yeah, that was scary. So lastly, cost. What's it cost? It really depends. Depends on where you live. I know it sounds stupid, but closer to major cities, the more expensive it gets. You go to Boston, go to New York, it's going to cost you more than it does in Springfield or Schenectady. It's just a nature of the beast. Is assume, if you've got a good idea of what a normal estate plan, which is will, power of attorney, healthcare proxy, HIPAA release, things of that nature, assume that the living trust, adding a living trust, is probably going to double that cost. In our area, I'd say anywhere from $300 to maybe $4,500, depending on the complexity of the estate. is roughly average. I do have attorneys we work with that are less than that. I have attorneys that we work with that are more expensive than that. But that's probably a good range of what we're looking at. So that will give you an idea. And again, like that client that, well, the kids can pay for it. Don't necessarily think of it as a cost. Think of it as an investment. Is what are you buying for that amount of money? Even if you're not the one that's going to realize it, your children or your heirs are probably going to realize it. So that's everything about living trust. And man, in 30 minutes, I threw a lot at you. I apologize. But it's a big topic. It's hard to break up. If I broke it up, it'd be like in 8-minute segments. That's just too short. So I just figured I'd just stick it all in at once. It's kind of like when you buy that sub that's just too big and you've got like a quarter left and you go, I should save this. And then 5 minutes later, you don't feel very good about yourself and you don't feel very good, but that sub is gone. You didn't have to worry about wrapping it up and saving it. That's what this episode's like. If you have any questions, jump down in the show notes and reach out to us. If you have an idea about a future podcast, I'm all ears. Definitely jump down into there as well. Reminder, on your favorite podcast app that you're listening, make sure you rate us. Give us a 5-star, please. And make sure you share this. This one especially because it's a lot of concept that people may not get, or you'll get it in legalese, as I try to keep these podcasts very, very vernacular. Is for a complicated word for a very simple way of talking. So definitely, if you liked what you heard today or saw today, make sure you share it with your friends and relatives. That's it. Stay safe out there.
Thank you for listening to Your Successful Retirement with your host, Dennis O'Keefe. Please click the follow button to be notified when new episodes become available. You can find information for Dennis, our guests, or resources mentioned in today's episode in the show notes.